8 justices, including some of the most reliably pro-gun rights members of the Supreme Court, just sided against a state law specifically written to protect gun owners, and only one justice disagreed. If you've heard about Missouri's Second Amendment Preservation Act and assumed this was a simple story of the federal government crushing state gun rights, the actual legal reasoning behind this 8-1 decision tells a very different and much more interesting story, one that has almost nothing to do with whether any individual justice supports or opposes gun control. In May of 2024, the Supreme Court denied Missouri's request for an emergency stay protecting its Second Amendment Preservation Act, letting a lower court ruling that struck the law down remain in effect. Justice Clarence Thomas, one of the court's strongest defenders of an expansive reading of the Second Amendment, was the lone dissenter. This case has continued developing well past that initial vote through a full appeals court ruling, a revised version of the law, and another round of Supreme Court review, all the way into this year, which makes it worth understanding completely, rather than just remembering the 8-1 headline from 2024. I'm going to walk you through exactly what this law tried to do, why even justices who are otherwise sympathetic to gun rights concluded it couldn't stand, and what this case tells you about the actual limits of state power when it collides with federal law, regardless of which side of the underlying policy you're on. Before we get into it, if you want legal breakdowns that explain why a ruling happened the way it did, instead of just repeating a headline that flattens a complicated case into a simple win or loss, subscribe and turn on notifications right now. This case is a perfect example of why understanding the actual legal reasoning matters more than knowing which side technically won, and it's exactly the kind of story where the loudest online reactions almost never match what the courts actually said. Let's get into exactly what Missouri tried to do and why it ran into a wall that had nothing to do with the Second Amendment itself. Here's what Missouri's law actually said, because the specific text matters enormously to understanding why this case turned out the way it did. In 2021, the Missouri legislature passed the Second Amendment Preservation Act, a law declaring that the state retained the power to judge for itself whether federal gun laws were constitutional, and asserting the authority to declare certain federal firearms laws invalid, unauthoritative, and of no force within Missouri's borders. The law specifically identified categories of federal action it considered infringements on the right to keep and bear arms, including any tax that might create a chilling effect on firearm purchases, any registration or tracking of firearms, and several other categories of federal regulation. Beyond simply declaring these federal laws invalid within the state, the law went further, prohibiting state and local law enforcement officers from enforcing or assisting in the enforcement of these specific federal firearms laws and creating a mechanism for private citizens to sue any state or local agency that violated this prohibition, with penalties reaching up to $50,000 per violation for the agency involved. The federal government, through the Department of Justice, sued Missouri, arguing the law violated the Constitution's Supremacy Clause, and the case worked its way through the federal court system from there. The first segment of this story is the specific legal doctrine at the heart of the entire dispute, because understanding it explains exactly why this case wasn't really about gun rights at all, at least not directly. The Supremacy Clause, found in Article 6 of the Constitution, establishes that federal law is the supreme law of the land, and that state laws conflicting with valid federal law are preempted, meaning they cannot stand. Layered on top of that is a related but distinct doctrine called anti-commandeering, established primarily through a series of Supreme Court cases in the 1990s and 2000s, which holds that while states cannot be forced to actively help enforce federal law, states also cannot pass their own laws that actively obstruct or penalize state officials for voluntarily cooperating with federal law enforcement. This doctrine has a genuinely bipartisan legal history worth understanding. It was first firmly established in a 1997 case called Prince v. United States, where the Supreme Court, in an opinion by Justice Antonin Scalia, struck down a federal law that had tried to force state and local officials to conduct background checks for handgun purchases, holding that the federal government cannot commandeer state officials to carry out federal regulatory programs. That ruling protected states from being forced to help the federal government. But the same underlying principle, that the federal and state governments each have to remain able to function within their own separate spheres without either one weaponizing the relationship against the other, has since been applied in the opposite direction too, against state laws that go beyond simply declining to help and instead actively punish officials for choosing to cooperate. That distinction between a state simply declining to help the federal government, which the Constitution generally allows, and a state actively punishing its own officials for choosing to cooperate with federal authorities, which courts have found crosses a different line, became the central legal battleground in the case against Missouri's law. The second segment is what the federal district court actually found when it first ruled on the law, because this ruling set up everything that followed. U.S. District Judge Brian Wimes ruled in March of 2023 that Missouri's Second Amendment Preservation Act was unconstitutional, writing that the law was invalid, null, void, and of no effect. Judge Wimes's reasoning centered on the distinction between a state choosing not to participate in federal enforcement, which the anti-commandeering doctrine generally protects, and a state actively imposing financial penalties and legal liability on its own officers specifically for the act of cooperating with federal agents on federal firearms investigations, which he found crossed into unconstitutional interference with the federal government's ability to enforce its own valid laws. The distinction matters enormously. A state genuinely can tell its officers, "We will not require you to help enforce this specific federal law." What the court found Missouri's law actually did was go considerably further, threatening officers and agencies with real financial consequences if they chose to cooperate with federal authorities even voluntarily, which the court found functioned as an unconstitutional obstruction of federal law enforcement rather than a permissible refusal to actively assist. The practical impact of this distinction played out in real, documented ways while the law was briefly in effect. Missouri law enforcement agencies reported confusion and hesitation about participating in joint task forces with federal agencies like the ATF and FBI, task forces that routinely handle cases involving violent crime, drug trafficking, and other serious offenses that happen to also touch federal firearms statutes, because officers and their departments faced genuine uncertainty about whether ordinary long-standing cooperation on these mixed cases could now trigger the law's financial penalties. The third segment is what happened when Missouri tried to keep the law in effect while it appealed that ruling, which is exactly the moment that produced the 8-1 vote everyone remembers this case for. Missouri asked the federal appeals court for an emergency stay, meaning a temporary order allowing the law to remain enforceable while the appeal played out, and when that request was denied, Missouri took the extraordinary step of asking the Supreme Court itself to grant an emergency stay. In May of 2024, the Supreme Court denied that request, allowing the lower court's ruling striking down the law to remain in effect while the case continued through the normal appeals process. Justice Clarence Thomas was the only justice who would have granted Missouri's request, dissenting from the denial. It's worth being precise about exactly what this 8-1 vote actually decided, because this detail gets flattened constantly in how the case gets discussed online. This was not the Supreme Court ruling on the ultimate merits of whether Missouri's law was constitutional. It was a vote on a much narrower, more technical question, whether Missouri had shown enough likelihood of ultimately winning its appeal and enough risk of irreparable harm in the meantime to justify letting an already ruled unconstitutional law stay in effect while the full appeal proceeded. 8 justices concluded Missouri hadn't cleared that bar. That is a meaningfully different and much narrower question than a full ruling on the law's constitutionality would have been. The fourth segment is why this particular legal question produced a lineup that surprised people who assumed this case would break down along the same lines as a typical gun rights dispute. The 8 justices who denied Missouri's stay request included multiple members of the court's conservative majority, justices who have written or joined opinions substantially expanding Second Amendment protections in other cases entirely unrelated to this one. Their votes here reflected the specific, narrower legal question in front of them, whether a state's anti-commandeering law had gone further than the Constitution permits by actively penalizing cooperation with federal law enforcement, not a referendum on gun rights generally. This is exactly the kind of case where understanding the specific legal doctrine at issue matters enormously, because a surface-level read, gun rights case, 8 justices ruled against the gun rights side, badly misses what actually happened. The federalism question at the heart of this case, how far can a state go in obstructing federal enforcement before it crosses into unconstitutional interference, is a doctrine that cuts across the usual gun rights debate entirely and has been applied by courts against state laws attempting similar maneuvers on completely different subjects, including state laws attempting to obstruct federal immigration enforcement and federal environmental regulation well before this specific Missouri case ever arose. The fifth segment is what Missouri's supporters actually argued, and their position deserves to be presented on its own terms, because it reflects a genuine and long-standing legal philosophy about federalism, not simply an attempt to nullify federal law without any constitutional basis. Supporters of the law argued that the anti-commandeering doctrine, developed by the Supreme Court itself in cases having nothing to do with guns, specifically protects a state's right to decline any level of cooperation with federal enforcement of laws the state's own legislature disagrees with, and that the specific penalties in Missouri's law were simply a mechanism for enforcing that choice consistently across every agency and officer within the state, rather than leaving individual officers free to cooperate selectively based on personal preference. They pointed to a real and growing body of state-level laws on other subjects, sometimes called sanctuary laws when applied to immigration enforcement, that similarly restrict state cooperation with certain federal enforcement priorities, arguing that if those laws are constitutionally permissible, a similarly structured law protecting gun rights should be evaluated under the same legal framework, rather than treated differently simply because of the underlying subject matter. Missouri's legislature and attorney general also argued more broadly that the state has an independent interest in protecting what it viewed as an extra layer of security for its residents' Second Amendment rights beyond whatever protection federal courts might eventually provide, framing the law as a genuine expression of state sovereignty within a federal system that was always designed to give states real independent authority rather than making them simple administrative extensions of federal policy. The sixth segment is what the federal government and the courts that ultimately ruled against Missouri argued in response, and it's worth presenting this side with equal care. Their position was that Missouri's law crossed a specific, previously established line, the difference between a state passively declining to help, which the anti-commandeering doctrine protects, and a state actively punishing its own officials with financial penalties specifically for the act of voluntarily cooperating with federal agents, which courts have consistently found goes beyond permissible non-cooperation into active obstruction of a functioning federal law enforcement system. They argued that if states could freely impose financial penalties on their own officers for cooperating with any federal law the state legislature happened to disagree with, the practical result would allow individual states to functionally nullify federal law within their borders simply by threatening their own officials into non-cooperation, which is precisely the kind of state nullification of federal authority the Supremacy Clause was written to prevent, regardless of which specific federal law or which state happened to be involved in any particular case. The seventh segment is what happened after this 8-1 stay denial, because the case didn't end there, and the later developments actually reinforce how narrow and technical the original vote really was. In August of 2024, a 3-judge panel of the Eighth Circuit Court of Appeals unanimously affirmed the district court's ruling, agreeing that Missouri's law violated the Supremacy Clause for essentially the same reasons Judge Wimes had identified. The law went beyond permissible non-cooperation into active, penalized obstruction of federal enforcement. That unanimous appellate ruling, from a full panel actually considering the merits rather than just an emergency stay request, confirmed that the 8-1 Supreme Court vote in 2024 wasn't some fluke or an overly cautious reading of an uncertain legal question. It reflected a conclusion that held up under full appellate review as well. Missouri did not give up. In January of 2025, the state legislature passed a revised version of the law, attempting to address the specific problems the Eighth Circuit had identified, while preserving as much of the original law's practical effect as possible. That revised law, and the ongoing legal dispute connected to the original case, made its way back to the Supreme Court on a petition asking the justices to formally review the Eighth Circuit's ruling on the merits, rather than just the earlier emergency stay question. In October of 2025, the Supreme Court denied that petition, declining to hear the case, which left the Eighth Circuit's ruling striking down the original law as the final word on that specific version, while the revised 2025 law faced its own separate legal questions going forward. Let's step back and name the single thread running through this entire case. This was never really a case about whether the Second Amendment protects an individual right to own firearms, a question the Supreme Court has already answered clearly in other cases entirely separate from this one. It was a case about the much narrower, more technical question of exactly how far a state can go in structuring its own non-cooperation with federal law enforcement before that non-cooperation crosses into unconstitutional obstruction. 8 justices, including several strong Second Amendment supporters, concluded Missouri's specific mechanism, financial penalties targeting officers for voluntary cooperation, crossed that line. Justice Thomas, in dissent, would have let the law remain in effect while the broader appeal played out. Understanding that distinction between a ruling on gun rights and a ruling on the specific mechanics of federalism and anti-commandeering doctrine is exactly what separates an accurate understanding of this case from the flattened, purely partisan version that dominated social media when the ruling came down. It's worth sitting honestly with why this case matters so much beyond Missouri specifically, because the anti-commandeering doctrine at its core cuts in every ideological direction depending on which state and which federal policy happens to be involved. The same legal principle that struck down Missouri's gun rights law has also been used by courts to evaluate state laws restricting cooperation with federal immigration enforcement, laws sometimes passed by state legislatures with very different political priorities than Missouri's. A state genuinely does retain real power to decline participation in federal enforcement priorities it disagrees with, on guns, on immigration, or on any number of other federal policies. What this case clarifies is that the specific mechanism a state chooses matters enormously, and that a law imposing direct financial penalties on officials specifically for voluntary cooperation runs into a different, harder constitutional wall than a law simply declining to require that cooperation in the first place. That distinction will keep shaping how state legislatures across the political spectrum draft resistance laws on a wide range of federal policies going forward, regardless of which party controls a given state house or which federal law is being resisted. If there's one thing worth taking from this breakdown, it's that an 8-1 vote against a state gun rights law doesn't automatically mean the justices involved are hostile to gun rights. And a case with major nationwide implications for how states can structure resistance to federal law is often decided on grounds that have very little to do with the underlying subject matter that made headlines. This case will keep shaping how other states approach similar resistance laws on other subjects entirely, from immigration to environmental regulation to any future federal policy a state legislature strongly disagrees with, precisely because the anti-commandeering doctrine at its core applies well beyond guns alone. If this helped you understand why this case turned out the way it did, share it with someone who assumed this was a simple gun rights loss, subscribe so you catch the next major ruling the moment it clarifies what actually happened, and I will see you in the next one.